Marios. And who will be representing group 2? Okay, group 3. Who will be representing group 3? Maybe someone could you kindly invite our colleagues from outside to join us, please. Sừng trên này. Okay, so we are all ready. Just one notification for our colleagues from outside Thailand, those who do not speak nor understand Thai. Group 2 will be presenting in Thai, so please make sure you have the equipment for interpretation group. That's for group 2. So you have the equipment there outside. So please make sure you have one set. That's for group 2. Marios will be presenting in English, I guess, not in catalog. So each group will be having about 10 minutes. Will you be able to do presentation in 10 minutes? Okay, good. Alright. So we start with group 1.
Good afternoon, Ajahn Kritaya and Ajahn Sri Prabha, and to all my fellow participants this afternoon. I have the honor to be assigned this very difficult task of reading to you all the comments and suggestions, recommendations put forward by all the members of Group 1. So if you have any questions, violent reactions, please you can do it later after I read everything, and all the members of Group 1 will be able to answer your questions. So regarding the 3 questions posted on the board, if the draft agreement is comprehensive, which provisions still need polishing or modification, or if the mechanisms provided are appropriate. These things, all the members of the group agreed that we are not totally satisfied with some of the articles or provisions in the draft. So I'm just going to read to you the suggestions and comments by article, okay? So to start with the preamble, we all think that the preamble emphasizes the importance, we should emphasize, the importance of the preamble, because it is a commitment that we have to make based on international standards. And then, so are we happy with all these articles or the provisions made in this draft? And how can we make it stronger? So these are some of the questions posed. So regarding Article 1, we look at the definitions, for example, of child labor. So it says here that child labor refers to those who are below the minimum age of 15. So some comments made regarding this definition is that in some countries 14 is acceptable. So there is a contradiction between the draft and also that which is acceptable by CRC. So we need to have a standardized legal age or definition of child labor. So all ASEAN countries should follow that. And another thing is that we have to clarify the type of work that young groups can do, because some sectors like the fishing industry, it requires hard work. So young people should not be allowed to work there. So that is for the definition of child labor. And for the definition of workers, we suggest that we have to expand the categories of workers to include informal workers. And also we need to look at migrant workers. So is the definition of a migrant worker based on status, or a migrant worker is a migrant worker regardless of status? So this is a question. And what about internal migrant workers? So because, for example, in Vietnam, there are problems when people move from one city to another city. So they have problems accessing services. So again, we need to look at not only international migrant workers, but also internal migrants. So this is country specific. And then members of the family. So it's defined here that this refers to persons married to worker or migrant workers. So why this only specifies married workers? What about those in other types of relationships? So again, we have to look at people who are also in other types of relationships. And in Article 2, number 7, we want to add something to this one. Let me find that out. Okay. Just a minute. Okay, number 7. It says here, the implementation of the provisions of the agreement shall be effected through national legislations. So we agreed through is better than by, but we have to add that it shall be brought into compliance with this agreement to make sure that each member state really would follow what is stated in Article 2.7. And then Article 3 is about decent work. Okay, so I hope you can find that. Page 9, Article 3, right to decent work and employment. So we suggest that decent work should mean, or the wages should be based on the cost of living instead of the minimum wage, because we have what we call the minimum wage, but actually it doesn't meet the actual cost of living. So it should be based on the actual cost of living. So we want to call it the living wage instead of the minimum wage. And for the same Article 3, number 6, every worker has the right to security of employment. This one should be linked with occupational health, which is in Article 9. And for Article 4, we try to edit Article 4, number 1 and 2. So we want to add on the second sentence, for the protection, this right includes the right to form and join trade union of his or choice and participate fully in social dialogue and labor issues. And then for the second part of Article 4, we want to add that in respect of all rights of union leadership and membership, and then enjoyment of the benefits of collective bargaining and union leadership and membership. So these are, I hope you can follow me. So now Article 5, we want also to change special protection, Article 5 special protection, which is in number 2. So instead of special protection, we change it to adequate protection, because special protection is very vague. We found it to be very vague. And then for Article 6, this article should reflect the provisions made in CEDAW, which is about women's rights. So just for all of us who are looking at this draft, we need to look at it again and make sure that the provisions here reflect the provisions made in CEDAW. And number 3, the bullet 3 should not only be for maternity and health of women, it should also include men, because men should be part of the paternity packages. And okay, so Article 8. So for Article 8, we have the right to nationality. So we want to expand it by looking at the mechanisms agreed upon by member states. So, for example, who should facilitate the nationality procedure or granting of the citizenship, and how do we make sure that the child gets a nationality and that that nationality is recognized. So that's for Article 8. And Article 9, again, we have to make sure that we follow the occupational safety and health standards, plus appropriate compensation discussed in Article 12. And then for Article 10, we want to expand number 1. So every worker has the right to access vocational guidance, occupational and skills training, and this should be provided by the employer, so it should be added there. And to add also that each employer should be granted access to higher or advanced one's education. So if the worker wants to be employed and also study at the same time, this should be granted to her. If the employee wants that, it should be granted to him or her. And okay, I think Group 1, do you want to add anything? Did I forget anything? Okay, so the last one is about the implementation, which is Article 17. So there was a suggestion that the adoption of the draft must have a consensus and then be ratified by the country, and the committee should meet the Secretary General. And the last comment from Group 1 is that we did not see any role of civil societies or civil organizations in the draft. In the committee, sorry. Yes. So that's it. Thank you.
Thank you, Rosemary. I guess the presentation focused on provisions that you feel need modifications to be addressed. Just to ask you to clarify on your last point about implementation, the committee. I'm not quite sure if I got your point well, because if you look at different provisions after provision 17, you see some part of it in kind of trying to make sure that there will be participation of stakeholders. So I'm not quite sure if I understand what you said well. But just for I just like to see further clarification on this point.
Sorry, anyone from the group you can add in, but I think just to say, in Article 17.2, it says shall be appointed by each member state, members of the committee. We have already got this experience in ASEAN where AICHA and ACWC is the two organizations are concerned. Some of it is done in consultation with CSOs and some of it are all state appointees. So that is where the CSOs come in. And I think this is an issue that we feel the CSOs ought to come in to be part of the committee too. Is that clearer?
Yeah, thank you very much. We for this part presentation we are on listening mode. So when we ask you, it's really for clarifications, but we are not commenting or making any comments on your presentation. So Group 2, please. As I said, should be presenting in Thai. So make sure you have your interpretation set.
On behalf to the representative from the group number 2, in my group we use 3 languages to discuss. Yeah, there's a Thai, Lao, and English. That means that I have right to choose the language to present to you. Yeah, that means I choose the Thai to present that. Okay? กลุ่มที่2นะคะกลุ่มที่2นี่เรามีคำถามอยู่4คำถามเรารวบคำถามนะคะ2คำถามแรกนะคะเราจะตอบ แล้วก็อีกสองถามหลังเนี่ยจะเป็นอีกประเด็นถัดไปนะคะแล้วก็ภาพรวมของการนำเสนอจะนำเสนอทั้งหมด3ส่วนนะคะก็คือส่วนที่1ส่วนที่2แล้วก็ส่วนที่3ดังนี้นะคะคือในส่วนที่1เนี่ยเรื่องของหลักการทั่วไปเราคิดว่าต้องขยายนิยามของคำว่าคนงานให้ครอบคลุมทุกส่วนนะคะอย่างเช่นคำว่า worker เนี่ยมันควรจะต้องเขียนให้ชัดว่าหมายถึงบุคคลใดบ้างเพราะว่า worker ในดราฟเนี่ยจะครอบคลุมประเภทของบุคคลทั้งหมดนะคะแต่ส่วนมันมีคำปรากฏคำหนึ่งคือคำว่า labor นะคะเพราะ labor นั่นจะบอกถึงเรื่องความเชื่อมโยงให้เข้ากับแนวนโยบายของ ILO นะคะเพราะฉะนั้นจะมีทั้งคำว่า worker และ labor อยู่ด้วยกันนะคะอันที่2ก็คือว่าขอบเขตของการนิยามควรจะครอบคลุมทุกประเภทคนทำงานนะคะไม่ว่าจะในระบบหรือนอกระบบนะคะส่วนประเด็นที่3เราก็ควรจะอิงเรื่องอิงหลักการของ ILO ไปด้วยนะคะโดยเฉพาะหลักการพื้นฐานของแรงงานอันนี้ก็คือบทสรุปที่เราคุยกันนะคะในส่วนที่1นะคะจากนั้นก็คือส่วนที่2คือเรื่องของสิทธิแรงงานนะคะคือเราเห็นว่าสิทธิในอาชีพและสิทธิในสุขภาพเนี่ยมีการกล่าวถึงอยู่แต่ว่าขาดเรื่องของอาชีวอนามัยนะคะและความปลอดภัยในการทำงานอันนี้ก็อยากจะขออันนี้ก็เป็นสิ่งที่เราเสนอขึ้นมานะคะแล้วก็เรื่องของสิทธิในการเกิดนะคะเห็นว่าประเทศที่เด็กเกิดสามารถออกเอกสารรับรองการเกิดได้นะคะเพื่อให้เขาปรากฏตัวตนขึ้นในประเทศนั้นนะคะแต่ก็มีข้อเสนอเพิ่มเติมมาว่าควรจะต้องระบุเป็นเชิงรายละเอียดนิดนึงว่าสัญชาตินั้นจะต้องได้ตามบิดาหรือมารดาก็ว่าไปนะคะเพราะว่าถ้าบอกว่าให้เอกสารได้เนี่ยก็อาจจะเหมามันคือเรายังถกกันอยู่ประเด็นนี้อยู่นะคะอันนี้ก็เป็นข้อเพิ่มเติมนะคะส่วนเรื่องของอีกเรื่องหนึ่งก็เป็นเรื่องของสิทธิในการเคลื่อนย้ายนะคะคือสิทธิในการเคลื่อนย้ายเนี่ยก็ยังมีข้อขัดแย้งกันนิดนึงนะคะว่าจริงๆแล้วมันเคลื่อนย้ายกันได้หมดจริงหรือไม่นะคะก็ควรจะมีรายละเอียดเพิ่มเติมนิดนึงว่าคือจะสามารถเคลื่อนย้ายได้อย่างเสรีหรือไม่หรือจะสามารถตีความได้อย่างไรเพราะฉะนั้นเนี่ยการความสามารถเนี่ยมันจะขึ้นอยู่กับแต่ละประเทศหรือเปล่าอย่างเช่นประเทศไทยเนี่ยคืออุดมคติเราก็คิดว่าถ้าเราไปทำงานที่ประเทศไหนเราควรจะเดินทางไปที่ไหนก็ได้ในประเทศนั้นๆนะคะแต่ขณะอีกประเทศหนึ่งบอกว่าเฮ้ยมันก็ยังไม่ได้มีเอกสารรับรองนะคุณจะเคลื่อนย้ายได้ยังไงนะคะแล้วก็มีการพูดถึงเรื่องของคือเราควรจะยกเลิกคำเรียกของแรงงานข้ามชาติที่บอกว่าผิดกฎหมายหรือไม่ผิดกฎหมายอะไรก็แล้วแต่นะคะแล้วก็ไม่ใช่คำว่า documented แล้วก็ undocumented นะคะแต่จริงๆแล้วมันก็ยังมีอีกส่วนหนึ่งที่เสนอว่าก็ควรจะเรียกว่า worker นั่นแหละนะคะไม่ควรจะไปแบ่งแยกมันนะคะอันนี้ก็เป็นแค่การพูดคุยกันในกลุ่มนะคะแล้วก็ส่วนเรื่องของส่วนที่3นะคะส่วนที่3เนี่ยเราคุยกันว่ากลไกเนี่ยมันขาดการขอโทษนะคะหาไม่เจอส่วนที่3เนี่ยขาดนะคะในเรื่องของกลไกและคณะกรรมการเนี่ยขาดระบบกลไกตรวจสอบแรงงานนะคะทั้งแรงงานในนอกระบบและในระบบนะคะอีกส่วนหนึ่งบอกว่าถ้าเราจะเป็นพลเมืองอาเซียนหรือเราจะเป็นอาเซียนจริงๆเนี่ยเราก็ไม่ควรที่จะดูแลเฉพาะประเทศของตัวเองเราควรจะดูแลพลเมืองอาเซียนของเราที่ไปทำงานที่ส่วนอื่นเช่นที่ยุโรปหรือที่นอกเหนือจากอาเซียนนะคะควรจะมีหน่วยงานหรือกลไกไหนที่ไปตั้งแล้วก็ดูแลพลเมืองอาเซียนที่ไปเป็นแรงงานข้ามชาติที่นั่นนะคะอันนี้เป็นข้อเสนอของกลุ่มที่3กลุ่มที่2ขอโทษนะคะกลุ่มที่2ทีนี้ก็คงจะต้องถามไปนะคะว่าสมาชิกกลุ่มมีท่านใดที่จะเพิ่มเติมไหมคะ
ค่ะ yes
Maybe you forgot the last point that we agree to present. Yes, the last point on the principle. Yes, we have two voice. One is follow to follow to ASEAN principle consensus of 10 countries. Thank you.
Okay, thank you.
Yes, we took note of the presentation and the intervention made by our friends from Laos. Not from Laotian government, but our friend from Laos. The third group, Adi?
Yes, thank you, Ajahn Supapa. I'm reporting from for the group 3, and if any mistake or anything that I forgot to report, please from the group 3 help me to add the report. We started with the Article 1 definitions. In these discussions, we were discussing about the definition of child labor, which is should be in line with the ILO conventions. And then one of our suggestions is to not putting the age on this definition of child labor, but using the term of age of school, because there are difference on term of definition of child. However, in term of the child labor itself, the age of school should be in relations with the educations. I mean, the labor itself is not the hard labor, but the labor that have the relations with their age, with their age of school. I mean, if they are still in the elementary schools, means that they have to have the connections with the educations. And then we think that definitions of migrant worker is sufficient enough. And then we also have the issues on the definitions of social security. On the definition of social security, I think we need to remove particularly, because particularly it's make these definitions more strict, and then it's the particularly it's more like an examples of the social security. But if we remove the particularly in this definition of social security, it will give broader definitions of social security. And also the term breadwinners, it's so European other than Asian. So I think we need to change that, because it's more right for us. It's rice winner than breadwinner. Or noodles. And then we move to Article 3, because we don't have any comment on Article 2. Article 3 on the paragraph 2 on Article 3, I think it should be, because if we see the ILO conventions, it's more like to equal pay for equal value, not equal pay for equal work. And then on the paragraph 6 of Article 3, that we remove the including provisions of alternative employment, relief work, and retraining. We change into the including protections from the terminations or dismissals on invalid reasons, other than to put the alternative employment, relief work, and retaining, but including protections from the termination or dismissal on invalid reasons. Okay, and then on the paragraph 7, we add the wording here, every worker has the right to rest period and leisures, including limitations of working hours, and rights to weekly rest or leave with pay. So that will be adding to the paragraph 7 of Article 3. On Article 4, we don't have any comments. On the Article 5, we have we made huge changes. On Article 5, we have to remove paragraph 2 and 3 into new articles. So the articles is Article 5 bis, if we can call it. So the title of the Article 5 paragraph bis is rights to maternity protections. And on the Article 5 bis, which is come from the paragraph 2 and paragraph 3 of Article 5, need to be rewrite, and also add in term of the adding cash medical benefit, including maternity leave, and also protections against discriminations and dismissals. And the last one is protections against heavy work during pregnancy. So that will be including in the Article 5 bis on the maternity, right to maternity protections. And then on the Article 6, we propose to change the title of the Article 6 to the rights to the gender equality. And then we replace the replace the rights to the something wrong with my on the wording, the rights of women's worker shall be changed to the rights to gender equality can be pursued, and then they will have the same words after that. So the rights of women workers, because the title is changed, means that the words on the rights of women is also changed to the gender, the rights of gender equality. Okay, and then Article 7 on the child labor, the use of employment on the paragraph 1, then second sentence, those who employ, the word employ should be changed to the word use, because use has more broader meanings than employ. And then on the paragraph 2, we need to remove paid, but and then adding the employment or work of the child is prohibited and punished by law. So the word will be, each ASEAN member state shall set age limits below which employ or work of the child is prohibited and punished by law. And then the next article is Article 8. We think it's very odd to have this Article 8. That's why we question, because it's come from the rights of the migrant worker and also the Convention on Rights of the Child. It's different from the usual ILO conventions. maybe the text need polishing in terms of the wording, because it's only mentions about the rights of the child, of the nationality of the rights of the child. And then in these discussions, we also thinking that the child is not only migrant workers, but also how about the stateless workers, whether the child can be give nationality or not by the ASEAN member state. So that's also the questions. If we can put that, it's going to raise the protections for the children, whether stateless or migrant workers. And then on the Article 9, the industrial accidents on the paragraph 2, because the work is not always industrial, so we propose to change into work-related accidents. So the health hazard at work and work-related accidents rather than industrial accidents. Yes, okay. And then actually it's and then on the paragraph 3, we concern because the migrant workers can and members of family can have the medical care when urgently required. I mean, when it's close to the death and they get the medical care. But that's in our discussions that is too narrow. So we need to broaden that. Then Article 10 on paragraph 2, we are agree because it's very generous for the ASEAN country to give education, especially for the child of the migrant workers. On Article 11 to 15, we don't have any comment. On Article 16, we agree to remove in particular and change into in addition on the first sentence of the Article 16. So all migrant workers and their families shall enjoy the rights recognized by agreement. In addition, and so on and so on to the migrant workers' rights. And then this is the last one on the Article 18. We don't have any comment on Articles 17. On Article 18 on the paragraph 2, I think we think we should give the word should be rewrite or policing, because I think we need to have in preparing the report in preparing the report consultations, including with the organizations of employee and also organizations of employer. So that will be the additions of the Article 18, paragraph 2. I think that's cover all our discussions in Group 3. If any other that I'm forgetting, please for my group to give any comment. Thank you.
Thank you, Hadi. And thank to our presenters from 3 groups. As I said, we are here on listening mode. I just want to clarify on 2 points here, just for your consideration. I'm not defending, but trying to explain. The first point is actually about education. The minimum age. The suggestion to use the the schooling, right? The school age. Because the school age in ASEAN countries is not exactly the same. Some countries, for example, Thailand, provide for 15 years of compulsory education, which means that the age is higher. For some countries, compulsory education may be only 6 years. So you may be having children below even 13 going to the workforce already. Just for your consideration that school age is not the same and the compulsory education is not the same. So that's the reason behind the fact that we put the age there. The second point is actually about Article 8, which is about right to nationality. In fact, if you look at the provision, it's quite broad. It's very broad. And we were thinking of not only children of migrant workers or children of stateless persons, but even within the country. Actually, I was mentioning earlier that in Thailand, you've got quite a large number of children who do not have Thai nationality. So it is applied across the board, not only specific groups of children in any country. So just for your clarification, 2 points that I like to share with you. Otherwise, again, I thank all presenters and the 3 groups. I think you were focusing on different provisions, provision by provision, but you might not have enough time to look at the implementation. So that's why the focus of discussion was on the provisions before, about the content of rights rather than the monitoring body. But anyway, it was very useful. Thank you so much. Pikrit, you.
I and Ajahn Sriprabha agree to combine the sessions together. So the last session will start now. The session on the way forward. Can we have a slide, please? And I asked the 3 presenters if you would like to be here. You can remain in the okay. I am not 100% well today, so I asked Ajahn Silva to assist me in moderating this session. Ajahn Silva will help in clarifying any points that you would like to raise, but she will not give her comments. She is not entitled to make a comment. We have anything that you think that is left over, you haven't said, or like Ajahn Silva just mentioned about the implementation part that all 3 presenters touch very little. You can say all this part more on this session. So what we would like you to join the discussion on this session is anything that you think it is the opportunity or challenges for further development, or the second point is how ASEAN member states could or should cooperate each other in its development. And the last point are what are the roles you think you can play. Yeah, we will have, according to our schedule, we will have, I think about at least half an hour for this session. So the floor is open now. Please raise your hand if you would like to make further comments, or you would like to re-emphasize the particular points that you think is important for you. Please. Yeah, 1 person. And anyone else? I would like to see at least 3 hands. 2 more, please. Second. Yeah, Singapore, Malaysia, if I'm correct. Anyone from other countries? Okay. From Vietnam. Yes. Please, the lady.
Thank you very much,
first thing I would like to say is that I think it's wonderful that this document is happening, and I see that as a great opportunity. The challenges that we actually discussed earlier in the group was the implementation. I know, Dr. Sri Papa, you mentioned the minus approach. We discussed the minus approach. There's a lot of skepticism whether it will work because of the ASEAN Charter and the government's feeling probably a little bit differently on this issue. So we felt that we don't have an idea, but we felt that under Article 17, maybe it needs a secondary measure. One of the suggestions was to go and meet the ASEAN SecGen, whether we should form a troika, whatever, so that the pressure points of the lobbying can continue. Unless one is so confident about the minors, so that is one of the big things that came up in the discussions. The second thing that I personally would like to raise is the harmonization of our work. We have CRC, we have CEDAW, we have CRPD, as has been mentioned. And I was also reading very quickly the ASEAN Declaration, which is in this book for everybody. The ASEAN Declaration on Strengthening Social Protection and all the provisions under there. Then I find that we use the word social security, not that it is all wrong, but I think we need to delineate and make this clearer on how we are protecting those who are in a bad situation and those who are building long-term income security for retirement and post-retirement. So, for example, me responding to the third group in that article to say, let's take out all the unemployment and old age. It is one of the requirements under social protection, the 9 stages of. So I think we need a bit more of clarity on this area for this document. And the last point I want to make is on the how ASEAN member states. I come from Singapore, and I think as a country that is primarily receiving, is in a recipient mode for migrant labor, and I wonder where this should be discussed, because there's also a growing income inequality between citizens and the, others who come to work in Singapore. So this document becomes even more important, I feel, when we talk about it as all workers, whether you are migrant, whether you are citizen, we are working towards equitability. I don't have an answer, but I think that might make a recipient country jump in more quickly than like what's happening to all my people and and all the rest of it. Yeah, so thank you.
Thank you. Arun, please.
Okay, there are a few comments to make. One is when we are drafting this agreement. The question is how the ASEAN member states is going to harmonize their national laws, and what would be the process to have this harmonization process, and how long it will take. Okay, what would be the monitoring accountable mechanism for harmonizing the national laws in ASEAN member states. Secondly, when we have all these rights or agreement on the workers' rights, okay, there are national laws like, for example, Immigration Act. Okay, when they use the Immigration Act, they actually supersede all other laws. Okay, so how do we tackle that? Okay, the moment they use the Immigration Act, all the rights are taken away. So that's important question we need to really discuss at this agreement or other layers of discussion. The third area, in our region also we have currently the asylum seekers who also are workers. Okay, so then if they use the other laws, so what happens as a worker? that when SLM seekers start working. So these are the three things I found this one here.
Okay, so you raise very difficult questions. Please, our delegate from Vietnam.
Thank you. I just have two very short questions, actually. The first question is about the next steps and the implementation of these agreements. We know that the ASEAN member states are quite reluctant to sign and ratify the ILO convention. The four of them we saw this morning on the slides, and some states just ratified two and some ratified none. So based on what do we have the hope and the confidence that they will go to sign and ratify our agreements? What will make them go that way? What will force them to sign and ratify? So what is the pressure we have? What kind of channel can we use to make them sign and ratify them? Even if they don't sign the ILO convention, where if they do it, the international standing will be much higher than in ASEAN. So this is my first question. The second question is, if I look at the different parts of the agreements, then some parts are more or less, let's say, not sensitive, like health, education, and minimum wage. Some parts will be very sensitive to certain countries. Probably the nationality question in Thailand, or maybe in Vietnam, that's a part of the freedom of association. So that's kind of a no-go area. You cannot go there. They won't shut off. So is there a kind of a second strategy for different member states to, I don't know if it's a good thing or not, but to choose certain parts of the agreement and ratify only that parts and leave out the others, just to get it working, So if we want to use that for bilateral agreements, maybe, between Vietnam and Thailand, we could pick maybe 3/4 of that and ratify that, but leave out the, let's say, the association kind of thing.
It's also the very next step that we have to think about. Would you like to clarify about the procedure of the next step, how to make the ASEAN governments to adopt or accept this agreement? Please.
Thank you, Happy. Thank you for all questions and comments, which are very, very interesting and useful. I think it's food for thought, really useful. I start by addressing the last question made by Zem from Vietnam. It's quite true that some provisions included in the draft agreement could be considered as sensitive by some ASEAN member states. We recognize that. But if we look at international level, at the UN, for example, actually the system at the UN, you allow a state party to either making reservations to the provisions that the government may not be comfortable with, then withdrawing the reservation layer when they are ready. That is one of the ways to deal with it. The second one is actually at the UN. I'm talking about UN that we know already. At the UN level, they also allow what we call interpretative declaration. So these are two of the ways to accommodate some countries which might not be fully comfortable with all provisions in the agreement. Actually, we may look at this as alternative to, I think, one of the comment made by one participant is how whether it would work when only after 5 ratifications then this agreement will enter into force, because 5 others where they are also having workers, including maybe migrant workers, not abide by this agreement. What would happen? It actually creates kind of double standard among ASEAN member states. So I guess this is a very good food for thought that we will have to think through. Secondly, ways forward. I guess Brema was giving some suggestion. for example, whether or not, of course, lobbying. Each of us will have to help in lobbying. You come from different countries, and we are really relying on you that when you go back, you may start discussing among NGOs, among civil society in your own country, and then also discussing with your own government. That's the way we could do at national level. Another thing that Brema was also suggesting, which is about Troika. In fact, we were discussing in the Law Reform Commission in the subcommittee. I was suggesting a kind of not roadshow, but visiting, Ministry of Labor of different countries in order to sell. This is a product to sell. So we have to sell this draft agreement. We have to sell our ideas, but of course with assistance of our friends in different countries. So that would be something that I could think of based on the suggestion made by Bema. But as I mentioned before, we broke out into the groups. That one of the things that we plan to do is actually to submit this draft agreement after revision based on comments and suggestions made by different forums that we have already organized. Submitting this to the Ministry of Labor as well as ASEAN Labor Minister meeting. That's what we plan to do. But as you know, although this is about the rights of workers, which fall under the purview of the ASEAN Labor Minister, but any decision in ASEAN would be made by the AMM, by the ASEAN Foreign Minister meeting, so we have to deal with them as well. And of course, this will enter into force only after, of course, the or acceptance by the leaders. So actually, it will take some time to go through different channels and different steps, but we have to go through different channels, definitely. Thirdly, this is the third point is about harmonization. Actually, this will be one of the challenges that even if the agreement was ratified by all 10 member states, and again I compare with the international human rights laws ratified by different member states, it usually takes some time for them to really harmonize international human rights law with the national laws, or rather opposite, harmonizing domestic laws with international human rights standards. This will happen with this agreement as well. That will take time, but in the same time, another challenge that we see, and that was, I guess, what Arun was mentioning, not only about harmonizing domestic